This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Glenn Edwin Shack. It's case number 2023 CR 435. Cheryl Pierce for the State of Kansas. Christopher Pate as defense counsel. Defendant Shack appearing in the office of his attorney, Mr. Pate. This matter comes before the court at this time for a hearing that was scheduled and added to the court's calendar. I will note that the matter had come before the court on October the 23rd. At that time, the court granted a request to set the preliminary hearing on December the 15th at 10 o'clock for an in-person proceeding. Mr. Pate, what is the nature of today's proceeding?
Well, there's a couple of issues, Your Honor. Ms. Pierce contacted me about 3 weeks ago and informed me that the state was going to be filing additional charges. I have an appointment set up with Detective Gatz on the 27th of this month to review that evidence. So I was initially requesting additional time for that. However, I had in my notes that this was scheduled for a preliminary hearing on December 11th, and I think Ms. Pierce did as well, because both she and I have been set for months to be in an in-person termination hearing, both the 14th and 15th. So I'm not sure where we got our wires crossed, but I think that's the same date Cheryl had as well.
It's possible that there was an original setting on the 11th. Some reason we moved it to the 15th, though it was apparently all done on October 23rd in everyone's presence, at least if I can have any confidence in my docket notes here. Ms. Pierce, your position here?
Judge, I did in fact add some additional charges. I did notify Mr. Pate of the same. I did kind of send out a email, if everyone recalls, that I had done that and that we might want to reschedule the preliminary hearing. That would give Mr. Pate time to get in there and view those images. And as far as the scheduling, Mr. Pate is right. I had it originally scheduled for the 11th. I had sent out subpoenas to the same. So I don't know what happened. I don't know how Mr. Pate and I got our dates fouled up, but we did. And we are scheduled in a 1.5 day long termination in front of Judge Leigh on the 14th and the 15th. So I would ask that we continue this joint request for a continuance, allow Mr. Pate time to get in there and view this. We have preliminarily talked about something short of a trial, a plea. We're not anywhere near ready to do that, but we have opened that door some so that we can perhaps, after Mr. Pate gets a little further down the road, come to some agreement short of a preliminary hearing. But that's the state's position, Your Honor.
I'll just note that this is the 4th time that this case has come before the court, and we're still not anywhere near, apparently, of getting through a probable cause determination. And Mr. Pate, I'll just share with you what I think I've shared with you before, that this court doesn't believe that the fact that you haven't seen full discovery holds up a preliminary hearing. After all, the very purpose of a preliminary hearing is for the state to show the defendant that there is evidence to show probable cause that a felony crime has been committed and that he committed it. So the fact, and I don't think that there's any requirement under any statute that requires you to have had discovery even provided to you prior to a probable cause determination. So the court will deny the continuance request for that reason. However, noting apparently that this case was originally set for December the 11th, I do note that my paper calendar reflects that there was a setting on that date crossed off. I also show it on the 15th. I can kind of see where perhaps the December 11th date came from, and I don't know exactly at what point the case was moved from the 11th to the 15th, but it was all included in my docket notes from October the 23rd. Perhaps right after our court proceedings, somehow someone realized a conflict and asked for it to be moved. For the reason that apparently both attorneys in this case are committed to a matter set in another court, the court is inclined to grant the continuance request for that reason and that reason only. I also note that Mr. Shack is out on bond and therefore would not appear to be materially compromised by what the court views as just further delay. Counsel, can we agree on a date that we can go ahead with the evidence in this case and get through it and have a probable cause determination?
Yes.
Yes.
How much time are you really anticipating now, given your second amended charging document and the number of felony charges continue to grow? So how much time is the state going to need to present evidence to show probable cause on these various matters?
Judge, I would suggest that we have at least the morning or an afternoon.
Thursday, January the 18th, starting at 1 o'clock. And
That
I'll just
works
let
for me.
counsel know that I do have duty assignment in Butler County on that date. Now, that's not a first appearance date, but I may have to take a break at some point to address any matter that might come up that requires my attention. I would generally be taking a recess at some point in the afternoon anyway, but I'll propose a 1 o'clock p.m. start on Thursday, January 18th. Ms. Pierce.
And just 1 minute, Judge. Tuesdays and Thursdays are usually my juvenile docket, but I do have somebody that can cover. So I will take that. It looks like there's not too much on that docket or not anything on that docket day. So so I'll take it.
Mr. Pate.
That works for me in person, correct?
Correct. Court will reset the evidentiary preliminary hearing in the Shack case to Thursday, January the 18th, starting at 1 o'clock p.m. in person, courtroom B, Butler County Judicial Center. Mr. Shack, okay. I need you to check into security before 1 o'clock. I want to make sure that we can get started promptly at 1 o'clock p.m. that day.
Yes, Your Honor.
All right. Mr. Pate, is there anything else we need to address currently?
Your Honor, Mr. Shack had requested that I ask the court to review his bond conditions. He's been out on bond since approximately October 1st. He's on a $50,000 cash or surety bond with EMD and travel restriction to Butler and Sedgwick County only. He was wanting the court to consider easing that travel restriction if it involves work-related travel, and also if the court would consider relieving him of the EMD requirement just because of the cost aspect of that. He's certainly glad to be out and appreciative of the earlier bond reduction the court gave him, but at this time he would make those requests, and I can tell the court he's been in good contact with me during the whole time he's been out on bond.
Pierce, your position on those relaxation of restrictions requests?
Judge, I would object to any further modifications to his bond or his EMD. He is not only looking at what are off-grid felonies, we've added several level 5 felonies as well. We are up to 9 different counts of possession or internet trading of child pornography. We started out with $100,000 cash or surety bond. We went to a $50,000 with EMD with modification that it could go to Butler and Sedgwick County for the purposes of work. My understanding is that he works at Total-Leigh. You modified his bond again on October 23rd to allow him to have contact with his wife as well as his employer. I think the court has allowed multiple modifications to assist the defendant in getting a job, holding down a job, being able to work through this, the pendency of this case, and move around quite freely. So I think that the court has made significant modifications and would ask the court to deny the request.
Mr. Pate, any reply argument?
He's not working at Total-Leigh. He's working remodeling.
Yeah.
Over here.
Drywall, finished carpentry.
I think he's actually prohibited from having contact with Total-Leigh at this point.
No. No, the court relaxed that restriction on October 23rd.
Okay. But he is not employed there at this time.
I agree with Ms. Pierce. I think that the bond was lowered substantially in contemplation that he would be on electronic monitoring, and the fact that his geographical location would be restricted to just Butler County, obviously this county, or Sedgwick, which happened to be the where his attorney's office is. It's the intention of the court to maintain those restrictions in place. I think that was all contemplated when the bond was lowered, and the court will deny the request for further modification at this time. Preliminary hearing is set for 1 o'clock Thursday, January the 18th in person.
Okay.
If there's nothing further then, the Glenn Edwin Shack matter will currently be in recess, and this meeting may be ended for all.
Thank you, Your Honor.
Thank you.